SRIRAM's IAS, serving the nation since 1985. Ab offline ho ya online, we are the lifeline.
Hello students, welcome to SRIRAM's IAS. This is another class of current affairs we are bringing for you for your upcoming prelims examination of 2025. This is class number 13. I am Mayank Bharadwaj presenting you this class of current affairs of Indian polity. A very important judgment has been given by the Supreme Court relating with a particular Article 39B of the Directive Principles of State Policy. So we are going to see and study two important articles and the whole judgment. It has very wide reaching implications on the Indian society and the Indian economy, also the Indian polity and how it works. 31C, this is a fundamental right, and at the same time 39B, this is an article in the Directive Principles of State Policy. So we know that few directive principles of state policy and for their implementation, even the fundamental rights are overlooked. This is a very important information which you should know. Although Article 13 protects all the fundamental rights, they are protected by Article 13, and Article 13 says that any law which is made after the commencement of the Constitution, or even if they existed before the commencement of the Constitution, if they infringe or are inconsistent or curtails or abridges any of the fundamental right, they will be declared as null and void. But in several cases, since India is a socialist economy, polity, socialist society, where the welfare of the people is the paramount, where concentration of wealth and its reduction is very important, the distribution of the resources has to be done in an equitable manner. These values are very important. There it is of paramount value to implement several provisions of the Directive Principle of State Policy, even if for that we have to overlook the fundamental rights, and this case is the one which establishes it. But at the same time, it also establishes the right of the people, right of property in a little manner. How has it done? We will see. And also it tells to the government that government cannot come up and declare any property, any material resource of the community as the material resource of the community, even if that is a private property. So basically and simply saying, no private property can be declared as the material resource of the community until proven so, or until its purpose is proven to the court by the legislature. So we will see this case. This is a very important case. This is the news of Indian Express. This was also covered in other newspapers. It was covered very widely. The issue were, does the phrase material resources of the community. Now if you read the text of Article 39B, you will see this phrase that material resources of the community has to be distributed equally. So equal distribution, equitably. Equitable distribution of the material resources of the community is what is given under Article 39B. Similarly, if you see Article 31, and some part of this Article 31 was struck down in the Minerva Mill case of 1980. So does this Article 31C stands as a whole? Does it still exist in the Constitution? Those were the two important questions which were in front of the Supreme Court in the judgment which has brought out in June of 2024. So we'll see this. Now basically I'll tell you the little background story of this. Let's read the context first, that a 9-judge constitution bench of the Supreme Court in the Property Owners Association versus State of Maharashtra, this is the case I am referring to, in 2024, held that not all private property can be deemed material resources of the community. We have seen this under Article 39B for acquisition and redistribution by the government. So if you have a building, if you have a farm, if you have a lake, all those things, if you have a small house, and on that small house there is a tree, do you really think that's your private property? And if it is your private property, can it be declared as the material resource of the community? Those are the things to be seen. Now, important to understand, let's say if you hold a big farm and this is like somewhere around 1 or 2 square kilometer, and there is a pond inside or a lake inside this property. This is your property, you are the owner of this property, but this lake feeds villages, gives water to these villages around your property, or to the village where your property exists, then this particular lake will be considered as your private property or the material resource of the community. Now this is one example. The other example is you have a multi-storied building and you are the owner of this multi-storied building and there are tenants living inside it. किराएदार रहते हैं 5 मंजिलों पर. Can this property which you own be declared as a material resource of the community under Article 39B? These are two different conditions from which you can understand where it is logical and reasonable to declare a particular private resource as the material resource of the community. Okay, but let me tell you about the background story. How this question came up, how these two questions came up, what happened, the background of it. It is very interesting. If you see in 1970s and 1980s, there were too many cases of falling of old buildings in Mumbai. So the monsoon is very heavy in Mumbai, and what would happen is that these old buildings which were 30, 40, 50-year old would just fall down, killing many people, injuring many more. So the government has to do something, and for that government has brought a bill. This bill was introduced in 1976. A particular amendment was made in 1986 and a part 8A was included in this particular act. Okay. Now this was to protect people, to save lives of those people who were living in Mumbai, in those buildings, those tenants. So let's say this building, you are the owner of this building and this building is in Mumbai in 1986. Okay. Now, what does part or chapter 8A says? It says that 70% of the people who are living in this building, और ये सब किराएदार हैं. So 70% of the tenants who are living in this building, if they permit or they request, then the government is going to acquire this building and the government is going to make this building again, or repair this building in such a way that it does not fall in monsoon seasons. So basically government was saving lives by doing this. But at the same time, you think about the situation of the owners. If you were the owner of this building in 1986 Mumbai, your property has been taken up by government, has been acquired by government. So it's a simple thing. What happened? The property owners approached court. When they approached Mumbai High Court said that, okay, there are two important articles in the Constitution, Article 31C and Article 39B. What does these two articles do? Article 39B ensures distribution of material resources to subserve the common good. Simply saying, Article 39B also includes material resources of community phrase. This phrase has become the point of contention, the basis of whatever we are studying today. So it ensures the equal distribution of all the material resources of the community. Now the whole question is, can the private property be included in the material resource of the community or not? And the second important article is 31C, which protects the laws aimed at equitable distribution of resources against challenges by Article 14 and 19. That simply means that any change or any law or any action which has been taken to implement Article 39B, that means for ensuring distribution of material resources, equitable distribution of material resources. If the government takes any step, parliament makes any policy, state legislature makes any law, that will be protected from the fundamental right, from part 3rd. That simply means article number 13 will not be applicable on any law, act or anything made to implement article 39B. I hope you have understood this. And in which article all these things are written? In article 31C. So let's go a little bit more further in the past. So the commencement of constitution, the date was 26th of January 1950. Article, fundamental right, holded very important power at that point in time, and still the scope of fundamental right are expanding, but sometimes fundamental right also come in the way of developmental works. One of those things happened. Article 31, which gave the right to property to many people, to all the people in the country, the right to property was made a fundamental right under Article 31. So if the government has to implement any land reform policy, if the government has to implement any policy regarding the infrastructural development in the urban areas, or government brings up some policy for urbanization, it has to acquire land. And when you acquire land, you know, Article 31 becomes a block. That simply means very strong property rights does not allow the government to do the developmental works, including the land reforms, which became a very important issue at that point in time in 1950s and 1960s. Okay, so Article 31 was there. So the government, in order to keep doing its welfareistic works, keep doing the important works such as the land reform, the urbanization policies, the infrastructural developmental policies, it has brought Article 31A and Article 31B. Article 31B and Article 31A says something what several laws can be made, or you know, property can be taken up or acquired for agricultural purposes and other purposes, and the judiciary does not have the power, or Article 31A does not have the power to stop the government from doing so. This is what was called written in Article 31B, which was inserted, 31A which was inserted, and 31B contained a specific provision for 9th schedule that anything which is contained in 9th schedule will not go for judicial review, that the judiciary does not have the power to review whatever is kept under 9th schedule, which is mentioned in 31B. So these two important articles were inserted by the first Constitutional Amendment Act in 1951 by the government to do important activities such as land reforms. I hope this much is clear. Now, in 1971, through the 25th Constitutional Amendment Act, now we see the Indira Gandhi government has came into power, and in 1971 another article 31C was inserted in the constitution. Now what does Article 31C says? What does Article 31C says? This thing, it protects the decision taken by the parliament, decision taken by the central government to implement 39B and 39C. So when the government is making any policy or taking any decision to implement Article 39B or Article 39C, that decision, that policy will be protected by the fundamental rights. The court cannot declare those policies, those law, those decisions taken as null and void because they are against Article 14 and Article 19 of the Constitution. So it gave a umbrella or a jacket or a bracket, you know, whatever you want to call it, it protected, Article 31C protected the government's action when they are taken to implement the directive principles of state policy, which are mentioned in Article 39B and 39C. I hope this much is clear. Then what happened? Then came 1976. Now from 1951 we have moved to 1971, and then comes 1976, the 42nd Constitutional Amendment Act of 1976. It has extended the scope of Article 31C and said that in order to implement 31C, in order to implement all the fundamental policies, the directive principle of state policies, 31A will protect all of them. That simply means any decision taken by the government to implement any directive principle of state policy, not only 31B or 39C, not only these two, 39B and 39C, but any directive principle of state policy, any decision taken to implement those directive principle of state policy will be protected by Article 31C. So if any policy which are implemented by the government, if it is challenged on the grounds of right to equality or right to freedom, right to equality, Article 14, right to freedom, Article 19, if any policy or any action or any statute of the government are challenged on the basis of right to equality or right to freedom, they will not be struck down because they are implementing Article 39B and 39C. Now this is a bit of a complication here, but I hope you are getting it. I am trying to make it more simpler for you, but seems like I am complicating the whole issue. So in 1971, 31C was implemented or inserted in the constitution. This 31C protects actions taken under Article 39B and 39C from right to equality and right to freedom. Means any action taken cannot be challenged on these two grounds. In 1976, under 42nd Constitutional Amendment Act, the jurisdiction of Article 31C was extended. Now, any action taken by government to implement the all of the directive principles of state policy, not only these two, but all the directive principle of state policy, any action taken, it will be protected by 31C. I hope it is clear to you. Now, this is the background of what all has happened. Now, coming back to this slide where we were trying to understand what happened in Mumbai. So in 1986, this chapter 8A was introduced, and according to this 8A chapter, your building can be acquired by the government if 70% of the tenant says so. Government was doing this to implement Article 39B. Government was taking this particular building as a material resource of the community. The simple idea of the government was that government is trying to save lives, and that is the reason why government is acquiring this building. But the owners were against this, because the owners, for them, this was their private property. This was their property which have been given to them by their forefathers, and government taking this up became a bit of a problem for them. Anyway, they were not earning too much money from the rents because of the rent control policies in Mumbai, but still it was their property. It was their prestige, and hence this is the reason they moved to the Mumbai High Court. Now Mumbai High Court have given up a judgment, and in that judgment it has favored the government's action, saying that government is taking up this building for repair under Article 39B. To implement Article 39B, that simply means government is good in its intent to declare this building as a material resource of the community, and government's action is protected by Article 31C. That simply means government's action are not to be challenged on the basis of infringement of Article 14 or Article 19. Means on the basis of right to equality and right to freedom, these things cannot be challenged. Okay, so the decision of the Mumbai court went in favor of the government, but the owners of the buildings did not stop and they went to the Supreme Court. Now, why we are reading this is because the judgment of the Supreme Court came in 2024 in the month of June, and what Supreme Court has ruled is something to see. Now we will see. So it is the case background. We have already studied about this chapter 8A, 1976, in this Maharashtra Housing Area Development Act. It was added in 1986, became a point of contention. So Bombay High Court's decision that upheld the Maharashtra law, stating that Article 31C bars challenges under Articles 14 and 19 if the statute furthers Article 39B. That simply means in order to implement the directive principle of state policy under Article 39B, even if 14 and 19, right to equality and right to freedom, are infringed, it's okay. The decision of the government cannot be challenged. That is what is written in 31C. So Supreme Court's verdict. Now this is something we have to read, and this is something which is very important for our examination. Supreme Court said that not all private property can be deemed as a community resource under Article 39B. Okay, and it established 4 criteria for determining community resources. What are these? Nature of the resource. What is the nature of that particular resource? Is it a lake which is feeding the thirst of many villages, or is it a private building? Okay, community impact. Resource scarcity. Let's say at your place the rare earth metals are found. Now you can become a billionaire with that, but the government is going to come and take it over because it's a scarce resource, and that resource is very important for the development of the community, for the development of the society, and the economic development of the country. And that is the reason why it can be acquired by the government under Article 39B and has to be distributed equitably among all. Now distribution doesn't mean that that piece of land will be named after everybody, but simply whatever resources which we take out from that, the fruit of that must not only go to you, but it must go to all the other people. So while acquiring that particular building in Mumbai in 1986, government was not paying enough money to the owners, the money in lieu of the acquisition of that property. That was also one of the contention. Concentration consequences. So these 4 criteria needs to be looked after by the state when it is declaring any private property as a material resource of the community. Not every building or every vehicle can be declared as a material resource of the community. I hope that is very much clear to you. So the Mumbai judgment went into the favor of the Maharashtra government, but this Supreme Court judgment goes into the favor of the private owners in Mumbai. But it has a wide-reaching implication in the society. The government always do this developmental work, and for that it acquires land. Now that developmental work is also important, but a fair compensation needs to be paid. And if it is not paid and the property, the private property, has been taken over by the government just because to implement the directive principle of state policy under Article 39B, now that is not permissible by the court of law. Okay, so the government has to prove that the acquisition made, or the government has to prove that any property which is taken as the material resource of the community for equitable distribution among all, government has to prove that this property falls into these categories. Okay, it has to prove that actually Article 39B is fulfilled by taking over a particular private property. Just because the act says, just because the government says, the acquisition of any private property cannot be done. It has to be proved by the government that that particular private property is for larger benefit. So it is a very important judgment by Supreme Court. So Article 31C. So government, Supreme Court has also checked upon the Article of 31C. Now coming back to this important slide which we were studying here. Now we have seen in 1931 two important articles were inserted, 31A and 31B. It gave a little flexibility to government to acquire land without the interference of the court and without the interference of the fundamental right. Similarly, 25th Constitutional Amendment Act in 1971 introduced Article 31C, which again gave the government to implement several policy, to implement the directive principle of state policy without thinking too much about the judiciary's interference or the fundamental rights becoming a block. Then in 1976, by this 42nd Constitutional Amendment Act, the text of 31C was changed. That means 31C was expanded. Now, in Minerva Mill case, what happened in Minerva Mill case in 1980, this Minerva Mill case of 1980, the changed definition of Article 31C. So Article 31C has two versions. One version which was there introduced by the 25th Constitutional Amendment Act in 1971. This version has a narrower definition of Article 31C, and this has a broader. Okay, here for the implementation of Article 39B and 39C, few fundamental rights can be abridged. But here for the implementation of any of the fundamental, any of the directive principle of state policy, the fundamental rights can be abridged. Now this definition, the broader definition which was introduced by the 42nd Constitutional Amendment Act of 1976 was rejected by the Minerva Mill case. Okay, now this has opened up a question, and the question was whether this narrower definition which existed before the 42nd Constitutional Amendment Act, this is invalid now or is it valid? Because the court has invalidated the newer, the broader definition. So does it invalidate the older definition as well, the older text of Article 31C as well? This was a question which was open and was not answered till now, but it has been answered by the Supreme Court in this recent judgment. So expanded by 42nd, we have already seen this. Okay, so the court said that Article 31C exists and the broader text was invalidated, but the narrower text still exists. That simply means Article 31C protects the government action for implementation of the directive principles of state policy under Article 39B and 39C to be challenged in the court of law on the basis of right to equality or right to freedom, on the infringement of right to equality and the right to freedom. So Article 31C and its narrower definition or its narrower text which was introduced in 1971 through 25th Constitutional Amendment Act, it still exists. Okay, I hope you have understood this. So this particular judgment was given by a 9-bench judgment of the Supreme Court 7 were in favor and 2 were against. So a different view was given by 2 judges. So Justice Nagaratna has said something, and Justice Sudhanshu Dhulia of the Honorable Supreme Court has said something. They have said that some private resources may fall under Article 39B. So the majority judgment is that no private resource can be considered as a material resource of the community. But here they are saying that some private resource may fall under Article 39B. But personal belongings should be exempt. Okay. Justice Sudhanshu Dhulia have said that he advocated for including all private resources under the community resource to address wealth disparity. That is 2 separate judgments, separate opinions written from those 9 judges. And this is the conclusion. The judgment strikes balance between private and property rights and community welfare, upholding the vision of economic democracy while protecting individual property rights. That simply means that government can do several welfareistic activity. Government can implement directive principles of state policy, and for implementation of that directive principle of state policy, several fundamental rights can be overlooked also. But they shall not be overlooked on arbitrary grounds. They shall not be overlooked just because the government thinks so. Simply means, if any policy, any law which have been made to implement the directive principles of state policy under Article 39B and under Article 39C, which is the equitable distribution of resources, if any policy or the act is passed, they can be protected by Article 31C, because the challenge on the right on the basis of right to equality and the basis of right to freedom may not be possible in the court of law. So government decision can be challenged, but the decision of the government has to be on the non-arbitrary basis, on the logical grounds, that the government has to prove that any particular private property which is now considered to be a material resource of the community, the government has to prove that it is really the material resource of the community. Okay, government cannot do it just because it is written in the act by the parliament. It actually needs to be proved. So there is no room for whims and fancies. There are no rooms for taking up some private property on any basis without proving it. So I hope you have understood this important topic, this important judgment for the upcoming examination, and I hope you study well for the upcoming examination, and we will meet in the next lecture with another important topic. Till then, thank you very much for listening to me and have a nice day. Jai Hind.